We're going to begin the meeting of the Federalism Commission. I'm co-chair Winterton, and we do have a quorum now. First thing up on is the approval of the minutes of June 12th. Thank you, Senator Hinkins. Discussion of the motion? Seeing none, all those in favor of approving the minutes of June 12th say aye. Aye. Any opposed?
Aye.
Okay. Just for information purposes, we want to give a status update of the Utah Valley University Federalism Tracker contract. And this is just to keep you informed, but the way that the contract was written, it's not meeting the goal that we wanted to reflect, and so we've redone the contract to reflect what they're actually doing for us. And this contract just needs the approval of the LMC, and then we'll move forward. They're going to continue doing what they're doing for us. So it's just bringing the contract in line with that. So that's for your information. Is there any questions on that? Okay, second up then, we got Article 5 discussion. And we've got Representative Ivory and Representative Kay Christofferson that's going to take some time to explain us a little bit about that. So we'll turn the time over we'll have Representative Christofferson come up to the table, and we'll turn on Representative Ivory's mic also. So however you guys want to do this.
Go down there and I can plug in, if that's all right.
Okay.
Sit next to my commissioner pal here.
While he's pulling that up, maybe I can explain what our invitation was. The Convention of States Foundation invited all of the states to get together in Virginia and Williamsburg and have a simulated Article 5 convention to just see how it would work if we discuss some of the possible amendments to be proposed to the Constitution, or and just have a discussion between the states on issues that we feel like the federal government may be not addressing. And so they invited every state, 3 members from each state, and all of the states were represented except for Rhode Island. A couple of states, I think, took off a little early, had to go back, but they participated in the initial stages of the convention. And what they did is they said, okay, we're going to take the 3 members of each state and we'll split into different committees and discuss some things that have been brought up. One was on fiscal restraint, dealing with our debt. Another one was on federalism, and Representative Ivory was the chair of that committee. And then another one that Quinn Cotter attended was on it was term limits. And so we had discussions on those one day in those committees, and then the next day they were all brought to the main body for discussion with everyone. And I had to leave a little bit early, but Ken can fill in the details on that. But I was in the fiscal restraint subcommittee, and it was very interesting to see what the other states thought about our debt and how we could solve it. And what was surprising to me is how many of the states, even some of the liberal states, felt like we've got a problem here that we've got to solve, and we've got to do it right away, or we're going to be in trouble. We're going to get into trouble with our national security, and we'll be a little bit vulnerable to outside influences. And there were some pretty strong opinions that we ought to take care of this right away. And we talked about a lot of different things, but we wanted to settle on one issue, and that was basically we wanted to balance our revenues with our expenditures. And, that's just kind of like, really, that's what we do every day in our homes. But if we could do that and then limit the ceilings, I think we limited it to 18% of GDP. And then we had 3 or 5 years to, if there was an imbalance, that we could balance that within a 5-year range and have an average of the last 3 years of receipts that we couldn't raise our expenditures above that. Now the Swiss implemented what they call a Swiss debt break, which is similar to what we have said. It was a pretty simple thing. They just said you got to balance your receipts with your revenues. And so the Swiss said, we're motivated to do this, and they've stuck to it. And I think they did it, I don't know, it was several years ago, 6 or 8 years ago, I think, and they have cut their deficit, or their debt, to a third of what it was. And their economy is great. They're showing some good signs, and they haven't really had a mechanism to pay off the debt, or to pay back the debt, but the economy is paying that down just as it grows, and they've been fiscally responsible to cut their expenses. And as they've done that, they've been able to cut into their debt. So anyway, that was the subcommittee I was in, and I'll turn the time over to Ken. He can talk about his committee and other parts. But Ken opened the convention up. He was the past president of the convention in 2016. So he opened the convention and conducted the elections, and then stepped back, and he was the chair of one of the subcommittees. But anyway, go ahead, Ken.
Yeah, no, thanks. Amazing experience. We've got, even though it was a simulation, to go through the process of how to conduct an Article 5 Convention of States was really fascinating. I think the biggest frustration was when we broke into the 3 committees to imagine having only a day to discuss federal jurisdiction issues, or to discuss fiscal restraint issues, or term limit issues. That was probably the hardest part and the most unrealistic. Obviously, if we had a call on the 3 calls of the Convention of States project issue, there's a number of different Article 5 movements out there. One is just term limits. Another one is just fiscal restraint. Another one is money in politics. And the Convention of States project movement has 3 issues that they seek to have a convention on, and it's fiscal responsibility, term limits, and then size and scope of federal jurisdiction. It's very apparent that if and when we do get to an actual Convention of States officially called, it's going to take months, right? Just the committee work will take months. To have a day to try to sort out and prioritize, which ones should we talk about, and which ones are more important. I had the Federal Jurisdiction Committee, and so we had countermand, we had things dealing with the 17th Amendment, we had issues dealing with overturning judicial decisions, we had, I'll tell you about a land proposal that we actually got in, but a number of things that way. So just prioritizing what to talk about would take a significant amount of time, but then to get the expert testimony and things in, I would imagine, I mean, we would be 3-4 months having expert opinion in, discussing the questions, looking at all of the ramifications, to even look in the committee before you had a committee vote on something they would send to the floor for a plenary discussion on whether or not to issue a proposal. So that was fascinating, just to try to time manage during the day to sort through. What Representative Christopherson was talking about on the Swiss debt break at the American Legislative Exchange Council meetings in Florida 2 weeks ago, we had the ambassador from Switzerland was there, and he was talking about this Swiss debt break and how that went into effect and what that meant and what they were doing. It passed on an 85% vote of the people, this Swiss debt break, and just looking at the things that they were doing and what went ahead. I saw something before getting into the specifics on the simulated convention. I learned something that I never knew before at the ALEC meeting. This Article 5, I don't know if I can get, Nathan, if I can get my monitor up. There we go. So this, it's the Article 5 library. I never knew that this was even there. You can search by subject, application subject. So you have balanced budget, you've got any number of different subjects that there have been applications submitted to Congress. We have such an issue right now of Congress not even archiving and counting and tracking, but this right to life. If you can see over here in the right-hand column, the tally that they're tallying, they're showing that in 1980, there were 34 live applications on right to life. Now, I haven't looked at the applications to know the quality of the applications going back, but someone that is archiving Article 5 applications is showing that in 1980, there were 34 live applications on right to life. On fiscal responsibility, for example, let me see if I can get back to that one. On fiscal responsibility, if you look at this, then 1979, they're showing 34 live applications. And then by 1983, there were as many as 40 live applications on fiscal responsibility. But we didn't have the computer technology back then that we have now. We weren't tracking and compiling the information the way we do now. But the fact that Congress isn't systematically receiving, archiving, and counting, apparently, is a major issue. And so as late as, as late as 2001, it appears that it was over 34, and then back again in 2015, and from 2015 until 2021, it appears that by some method of counting, and that is a question, by some method of counting, there were 2/3 of the states that had applied to have a convention of states on fiscal responsibility. And so that gets to a second issue that we'll get to as we look at the updates on this simulated convention of states that Representative Christopherson talked about. I'll come back to that. But just the importance of Article 5 and the things that are out there that are happening. At the simulated convention of states, we passed, I believe there were 6 proposals that passed the general plenary session. So we met Wednesday evening, Thursday morning, as Kay mentioned, I kicked things off, and then we elected a president, a former representative from Louisiana, a gentleman named Woody Jenkins, and he then presided over the convention. A gentleman from Oklahoma was the vice president, and then we split off into the 3 committees and spent all of Thursday working in the committees trying to prioritize and then wordsmith the different areas that were prioritized. And I'm sorry, I don't have a really good list down, but it says Proposal 1 was a term limit proposal, and I really kind of liked what they came up with. I thought it was pretty elegant. it said that no person, and so it was kind of an eligibility, no person shall be elected to more than 9 terms in the House, nor more than 3 terms in the Senate, but that they could serve no more than 24 years. So you could serve 18 years in either body, but you could not serve more than 24 years total. So you could go back and forth, and the idea is, a lot of the discussion was interesting. The first time I went, I was kind of opposed to term limits. Personally, I thought the voters are term limits, but when you look at, in either party, you have basically 3 people in the House, 3 people in the Senate that control the agenda. They decide if something goes to committee, if there are debates, if there are discussions, and really you have 3 people that kind of control what happens in the House and Senate, and if the parties change, then it's 3 people in the other party that control the debate. You don't see the kinds of debates that we have here that, things go to the floor, you do debate the issues. So that was the first proposal that came out. There were a number of amendments that were attempted to that we had a really robust discussion on those that dealing largely with judges and court decisions and some things that were defeated. But the ultimate proposal that passed on a 43-5 vote was this 9 terms in the House or 3 terms in the Senate, but no more than 24 total. Second proposal was just simply to put in the Constitution that the Supreme Court consists of 9 judges. And there were a number of proposals that were attempted to add to that, dealing with overturning court decisions and a state power or a congressional power to overturn court decisions. We had a really robust discussion on the law of the case and how things would go there, but that was ultimately passed on a vote of 39-8, and that was in the morning. Then in the afternoon, we got to Commerce Clause, and there was a proposal to define what Commerce Clause meant, to really kind of define that we would not have this expansive definition of the Commerce Clause that would allow Congress to go into any area that they wanted to, that it really restricted it down to interstate commerce. And so that we had a really big discussion on that. That ended up passing 46-2. And then we came to my favorite one. We had a proposal to deal with ceding care and management of public lands to willing states. And so we had a proposal that dealt with prohibiting Congress or the federal government from owning land other than for enclave clause purposes, and that they could own no more than 10% of land in any given county without the express consent of the legislature. And we ended up getting support from counties across the United States, because there are counties in Arkansas and South Dakota and North Carolina that have as much as 70-80% federally controlled land in their counties. And so by limiting how much federally controlled land per county, there were a lot of people that came into the debate that weren't what we would typically consider Western states, and then it gave us the opportunity to educate on, what the Western states looked like from 1820 to 1870, and our friends from Illinois that were 98 3/4% federally controlled from the 1820s to the 1870s. We were able to show them the resolutions that they sent to Congress, and our friends from Florida. And I think after a really robust debate, we of course exempted out military and tribal and national parks, wilderness, and national monuments as of the date of FLTMA being introduced, because that's when we started getting the 1-million-acre monuments with the stroke of a pen. And so as we got into that, but I think the most gratifying experience for me from the whole simulated convention was that passed on a unanimous vote. Every single one of the states there could see the benefit as we got to talking about how they're paying billions of dollars for our forests to be managed in a way that encourages fire. I mean, the Forest Service gets paid when the forest burns. That's when it gets money, and they're paying $3 billion a year for the forest to be managed to burn, because that's how the Forest Service gets revenue. And as they saw these things happening, and then also the case that came up not too long ago, this Shelby County versus Holder, that talks about the constitutional equality of the states is essential to the harmonious operation of the republic. And when you have states that aren't able to tax land and they're subject to federal transfers to even exist in many of the counties, they were able to see that the ability to have certain states be exploitable because of that difference, it was just really gratifying. It was really gratifying to see that states across the spectrum could recognize that this certainly was not the origin of the public land trust and the ability to have that harmonious operation. So that we had a fiscal responsibility proposal that passed, and where Representative Christopherson mentioned the 18%, that part was taken out, but it was basically expenditures can't exceed revenues over an average of 3 years, a 3-year average of revenues. And then if there were any surplus, that would be applied to debt. I think there was one other piece added to that, but there was a really robust debate on that. You can imagine in an actual convention, again, the committee meetings on those and the discussions for how those would work would take a substantial amount of time to have, economic experts and others in. So that was the simulated convention. We were thrilled on that. Go ahead.
Yeah, I just wanted to say a little bit on, when the founders were working on the Constitution, George Mason wanted to make sure that they added a way that if the federal government, which they were really suspicious of a federal government at the time because they just ousted King George, and they didn't want to get into a situation like that again. So they wanted a way that if the federal government began to overreach or were taking on authority that they really didn't have, that the states had a way to get together and say, look, we want to assure our jurisdiction as states, and we want to make sure that the federal government stays in its lane, and we want to protect our rights as states. And so Article 5 was a way to say we can propose amendments just same as Congress, and then those amendments go through the same process as for ratification, no matter which one proposes the amendment. So Congress has proposed amendments, three-fourths of the states need to ratify those to become part of the Constitution, and the same way with the states proposing amendments. And so this simulation was just a way to say, look, this can be done, it can be done systematically. We had rules that we ran by. It was very deliberative, and it just kind of helped to show what that process would be like in the event that we were able to be called into a convention. And my thinking is that if a real convention were to be held, I think that we probably just limit that. I think it would be more responsible, I guess, to limit it to one item at this point to begin with, just to show that it can be done, and it doesn't just deal with any issues. And I think one issue would be a lot easier for the states to ratify and get behind. So I thought it was a good exercise, and at least it shows Congress that we're looking at it and that we're interested in those things, and they may pick up the ball and do it themselves. Who knows? But we'll see how that goes.
Yeah, Nathan, if you can pull up, I can just show you just a little bit of what it looked like. I've got, and then plug it back in.
Okay, while you're doing that, let's go to Senator Owens. He's got his light on. Oh, no, Representative Aldrich.
Thank you, Mr. Chair. So, there's been more than enough states ratify participation to have one of these. And then some rescinded and some wavered. Where does that stand, and where, who would decide where it's held and how many delegates from each state and so forth?
Yeah, those are great questions, Representative. So that was actually the next part I would address, but let's address it now. So as you saw, there were at least two issues that it appears that there were 34 live applications. One of the questions is who would get into the weeds of qualitatively deciding if there were 34 applications. And we've been having some discussions with some very prominent legal scholars on this. I think the better approach and the majority wisdom at this point is that Congress, we should not have Congress getting into the weeds and deciding how close applications are to each other to decide whether or not to call. If there are arguably 34 states on a single subject, then what it tells us, Congress's role is to determine the time and place, period. They say it's a ministerial duty. They name time and place, that's it. So then, just like we had here, you'd convene the convention, you'd credential the delegates, and then it would be the convention of the states themselves that first order of business after electing officers and locking in their rules to decide, do they have 34 applications that aggregate on a subject? And if they didn't, then they'd all go home. If they did, then they'd convene and go forward and work. So
what's the perception on how many delegates from each state?
yeah, and so that's a great question. That's entirely up to the state. So we determine that. The legislature determines that. So we could send 100 delegates, but the convention would likely limit 3 delegates on the floor. And you get one vote per state. So if you wanted to send 100 and you had to poll 100 on each question. But the other thing then, as a state, we would send instructions to delegates. And we've also done some law. We have some law in Utah on delegate limitation. So if we send delegates and they consider things outside the scope of the call, it's actually a crime in Utah. 14 other states have done that as well. So it's the legislature that picks the delegates, controls the delegates, gives instructions to the delegates. We would even have a management committee likely that would be here now with the communication that we have, that we'd be monitoring, and we could give instructions to the delegates as things go along. And then obviously we'd want to pick people that know the process and have influence in the process. But yeah, it's a legislative mechanism. In fact, one of the founders, a guy named Tench Cox, as he was in the New York ratifying convention, he says the supreme authority, sovereignty, is not the federal government, as a lot of people suppose. He says the real point of sovereignty is the state legislatures. If 2/3 of them apply for amending the Constitution and 3/4 ratify, it becomes part of the Constitution without any interference of Congress. He says that's the real point of sovereignty. So state legislatures, as we come to know that and we see these problems, we can't point to Washington anymore and say, man, those guys, it's really, we have that authority to deal with that. And then the next point that I'll get to, Representative, is there is a very active movement right now. There's a Northeast governor and attorney general that have indicated they're willing to initiate a mandamus or declaratory relief action. I've been on calls over the last couple of weeks with some of the top Supreme Court litigation attorneys that we have in the nation today to discuss how to bring either a mandamus or a declaratory relief action on those two different areas that we've looked at. Probably it would be fiscal responsibility for the reasons that Representative Christopherson said. But at a minimum, to bring an action that says, Congress, you've got to start counting these, and you've got to keep an active archive, and if you get arguably to 34, you've got to name the time and place, period, the end. And so I think that action is very ripe, and I think it was in our May or our June meeting that we instructed the chairs to talk to the AGs and the governor's office and see what kind of support we had. And Our Attorney General's office indicated that maybe the legislature has standing on their own to bring that action, but it'd certainly be better if we joined with a northeastern governor and you know, you have a northeast and a western state that goes in, and if we were to launch that action, I'm certain other states would join in, and we got to at least have the answer to the question. Congress, are those live applications, and how close is close enough for you to name the time and place? I think it's really ripe to get those questions answered.
Thank you.
Okay.
So with your permission, I'll play just a little bit to give you a sense
Yeah.
of what this is like, and you can kind of, I won't play it all, it's 7 minutes, but I'll just play a few minutes. You'll get the sense of what this was like. That's audio's not going through.
And so I would submit to you that we have before us an opportunity to rectify one of the greatest constitutional affronts that you find in Article 4 of the Constitution. The only reason the federal government ever held title to any of these lands, just like Illinois, just like Florida, just like Arkansas and the rest, was as a trustee to dispose of the land in a timely manner. And we have a trustee that, since the beneficiaries forgot the terms of the trustee has said, must be mine. But those were the terms of the trust. You'll know that when Thomas Jefferson acquired 530 million acres of land, he trusted the people with land and with liberty. And there was the greatest economic explosion that the world had seen to that point. We're talking potentially about 30% more land than the Louisiana Purchase.
Section 5, and the present Section 5 moves to Section 6.
And it may be that since that was passed on another one, that could, 6 could even be.
This was a gentleman from Virginia then amending to make sure that
Section
military,
5 to read, this
tribal,
amendment
and
shall not apply to lands or military installations with respect to which jurisdiction has been ceded to the United States by a state, lands belonging to an Indian tribe, or to lands that, as of January 1st, 1976, are designated as national parks, national monuments, or as congressionally designated wilderness under the Wilderness Act of 1964, 16 U.S. Code, Section 1131, at segue.
All right, so an amendment has been offered up to exempt certain lands from this.
Dealing with one of the proposals that came out of the Federal Legislative and Executive Jurisdiction Committee. It's the one involving federal land ownership. So I can tell you, because I was in this committee listening, this was a big subject of lots of debate. And I think they're just fine-tuning it right now. Right, Mark? They're talking about things like, you know, the Indian lands and national parks and mineral rights. There's a lot involved in this. What are your comments or thoughts on what they're doing right
Yeah,
now?
look, this one is complicated, and I know there was a lot of debate in committee, a lot of time spent on this. Representative Ken Ivory from Utah, this is literally his life's work.
Yeah.
This is the thing he's most passionate about. He is probably the foremost expert in the country on this subject, so really a blessing to have him here addressing this. He knows the history.
Yeah.
And I think you're going to see them take the authority over most federal lands away from the federal government. I think this is a big deal.
Yeah, this is a big deal for a lot of the western states in particular, right, Mark?
Yeah.
So Utah, Montana, Idaho, a lot of those states have a big issue with the federal government.
Dakota.
and then you.
Tennessee. Texas. Utah.
Arizona and the other western states and ourselves and our posterity will die.
Vermont.
Arizona kept teasing us that they felt like they were left out.
Washington. West Virginia.
Yes.
Wisconsin.
Yes.
Wyoming.
Aye.
Mr. President, we have 47 ayes, 0 noes, and 2 absent.
47 yeas, no nays, and the proposal is adopted.
cool. Kay had gone by then, but, you know, to have that pass unanimously was a really, really amazing experience. So anyway, that, we stand right now on the Convention of States project, the 3 different issues. I believe that stands, the current count is 19 states have passed that application. Fiscal responsibility alone by itself, there are arguments that that stands presently at 32, but then as we saw back here, you know, the question is, if you got the ball over the goal line, do you put the points on the scoreboard or not? And the ball was over the goal line, they didn't put the points on the scoreboard. So that's where the legal action comes in, and we've got, you know, the Northeast state, and we have the opportunity. They're ready to bring the action. They would like at least one other state to go with them. So that's where, you know, Utah, if we decide to go with them, I'm certain other states would as well. And that's live discussion right now because we've got that there. And then there are a number of other proposals that are out there as well. So, Mr. Chairman and committee members, that's the update so far on some of the things that are out there. Be happy to answer any questions.
Okay, any other questions or follow up with them? Okay, thank you. Thank you for your help and participation on the federal side. Okay, next, we've got several topics, but while you're there, Representative Ivory, why don't you give us an update on cap and trade? That was also addressed back east, and
Yeah.
just a high level, whatever.
Right. Yeah, my apologies. I had a tooth pulled out, and it's been kind of been struggling to talk through all these things. So a lot of pieces have come together over the last few weeks on this, and I think you all might remember that when President Obama was running for office, he made this statement.
Under my plan of a cap and trade system, electricity rates would necessarily skyrocket. Even, you know, regardless of what I say about whether coal is good or bad, because I'm capping greenhouse gases, coal power plants, you know, natural gas, you name it, whatever the plants were, whatever the industry was, they would have to retrofit their operations. That will cost money. They will pass that money on to consumers.
And so that, we know that 3 times that failed legislatively. But then what happened coming into this administration, there were those that pushed this 30 by 30, that if you read behind the people pushing this, it's really a 50 by 50 to lock up 50% of land and water. And then this is still a live website, this Climate President Action Plan, or climatepresident.org, and it lays out the 10 steps that they've instructed President Biden to do, and about 9.5 of those have been done now. So this was in December of 2020 that they met with the Center for Biological Diversity and others, met with him and said, these are the 10 things. The one that hasn't been done yet is this declaring a climate emergency, and the way that fits in with the others is if you go back to this website and read their legal briefs, in the legal analysis that they have at this site, they say that upon invoking the Defense Production Act, which the President has done, combined with declaring a climate emergency, they claim that gives the President 130 unilateral powers and then control of most of the defense budget to move the climate agenda. And so that's in the legal analysis that they have at that site. And that's the importance of this declaring the climate emergency. And so that's why you're hearing that in the news frequently. And so then the executive orders, they did the executive order on the 30% of the land, the executive order on the reducing the carbon and adjusting the royalties and shutting off the land. This was significant. So this was in May of 2021, the executive order that did cap carbon levels that President Obama talked about, that did say that they would give preferences to bids for those that have the lowest cost of social cost of greenhouse gas, that did take into account into loans and insurance and underwriting climate-related financial risk. That would ostensibly even be Fannie Mae, Freddie Mac that, that underwrites 70+% of the home mortgage market and others, but that they would take climate-related financial risk into all federal-related transactions. And then in their implementation documents, they remind us that the federal government's the world's largest purchaser of goods and services, and they'll use that power as a tool to strategically shape the markets, and that was the intent in moving this forward. And the whole government-wide approach, and we've looked at a number of these things, that now you've got agencies across the spectrum that have their 30 by 30 plan, decarbonization plan, and environmental justice plans, and so they're all part of those executive orders, and all of these various agencies have their different plans. But the SEC is really the key, because it's the SEC that has the proposed rule to track the tier 1, 2, 3 carbon emissions, financial-related carbon risk. So not just the public companies, but their suppliers, and then the suppliers of the suppliers, and that's virtually every company in America at that point. And whether or not the Supreme Court ultimately overturns that rule, they've already been implementing it, and because it's being done in Europe, it's kind of what, on this video that I shared before, that President Biden said between now and 2030, we want to make it irreversible. So they move the actions out there, and it just becomes irreversible whether or not the Supreme Court takes it back. I won't, I'll share the video with you if you want. It'll be online. But they talk about using the tobacco and asbestos and opioid models in criminalizing some of those things. So you've got the environmental justice scorecards and things that are out there. Groups that are trying to make ecocide one of the crimes against humanities. Like genocide is a crime against humanity. There's a major movement to have ecocide be listed as a crime against humanity, and they list ecocide as these sorts of things.
Just a minute.
Mr. Chair, I don't think we should compare anything to genocide. And so not all of us on this committee actually feel opposition to environmental justice. So I know you're going through your presentation, but I just want you to remind the good representative that not everyone on this committee, I know we all don't think the same. And so I just be very cautious with how you frame things.
Yeah, Mr. Chair, I mean, just if you would, I'm just simply, putting information out that's out there, and you can draw the conclusions that you want to draw. I'm not, these are the things that are out there, so committee can draw the conclusions they wish to draw. The New York Stock Exchange did then open up the opportunity to list what's known as natural asset companies. And so they're now listing, this is a New York Stock Exchange site, where companies that have what they call an environmental asset, they can then do an IPO and list that and then sell environmental services, as they say. World Economic Forum talks about this as a circular economy and a new type of ESG investment. And then the way they describe it is that if you have a natural asset, you secure the rights to it, you do an IPO, and then you can sell the environmental services. And there are those out there that estimate that the market on selling environmental services is in the thousands of trillions of dollars. That this is the estimation of the next biggest financial market that exists, the commoditization of nature. And so this administration then did some proposed rules to put natural assets on the balance sheet, and then that was finalized in January of this year, where they talk about the standard approach to track the economic value of nature and to quantify the immense value of the natural capital. And it was on this foundation then that we got the conservation leasing rule. It was 2 months after this natural capital accounting rule was in place that then we got the conservation leasing rule to take what was multiple use sustained yield. And if you think about it, Western states, the promise was we would have the same rights to use the land and get benefit from the land. And up until 1976, we were still saying, hey, we want title to the land. And they said, we'll give you multiple use sustained yield. It'll be just as good. You get to use the land. Well, what about property tax? Well, we'll do PILT, payment in lieu of taxes. It'll be just as good as property tax. It'll be the fair taxable value, and we'll true that up. And those were the promises in 1976. We know what happened with PILT in terms of being fair taxable value. So now the multiple use sustained yield with the conservation leasing rule goes away, and the land is then leased for non-use. And in the BLM statements for this, the conservation lease, time-limited lease of public land, allows interested organizations to conduct specific restoration mitigation activities and generate revenue. This tool has the potential to expand opportunities to establish carbon markets. And obviously in the carbon markets, those exist worldwide. And then the last piece that really fell into place was 2 weeks ago, 2.5 weeks ago now, the Federal Reserve instituted what is known as the FedNow. And the FedNow, they'll say it's not a CBDC, I even forgot the acronym for CBDC. It's the Central Bank Digital Currency. They say it's not a CBDC, it's a fast payment system that is 100% interoperable with CBDC. So the fast payment system, they talk about being able to, when you deposit a check and it takes 3 days for the check to clear, under a fast payment system, it would clear instantaneously. So on cross-border transfers, the money would settle instantaneously. And then these are some of the players that are all part of the initial rollout of the FedNow. But the downside on the FedNow is the potential for it to be completely transparent, that it's completely open on what the transfers are. And so the concern that many have raised is that if you're then into a transfer system that we've seen lately on some of the issues with the federal government, where people have been shut off in social media types of things. And we've seen in Europe and in Great Britain, we've seen some of the opposition parties they've been debanked because of their political opinions and philosophies. Nigel Farage was the leader of one of the parties in Great Britain, and he was shut off from a number of banks. And so the concern on that, particularly when the discussion has been that if you don't have the right level of greenhouse gas, you don't get to participate in commerce. Those are different pieces of information that are out there that are very concerning. And this is just the last piece then, Mr. Chair, that on October 1st of this year, Europe goes live with their cross-border adjustment mechanism, their carbon tax. So on October 1st, U.S. companies will be getting taxed and getting carbon tax for doing business in Europe. And so it seems that there could be a lot of discussion about what the United States would want to do on Europe leveling carbon taxes on American companies and the disadvantage that would put American companies at. And it would seem from the pieces that we've seen, from the executive orders, from the administrative rules that have gone through, that the pieces are all in place where now the federal lands are leased to NGOs that then have the ability to have environmental services and do IPOs and sell climate services back to those that don't have the right level of greenhouse gas, that if they were shut off to participate in commerce, it appears that we have the pieces in place that we have basically potentially a compulsory cap and trade system that President Obama as a candidate talked about when he was coming in, that again didn't go through legislatively, but it appears that both from executive order and administrative rule, the pieces are all in place now. And so that was the update that we talked about last week at some of the legislative meetings and the discussion. And so now, both in the Senate and the House, talking to House and Senate leadership, they're both extremely concerned, and they've simply looked to this committee and to us to discuss what do we do, what are some of the things that we could do about this. And there are anti-commandeering, coercive spending, legislative enactments, education, certainly refusal to cooperate, standing with other states, but both the Senate and the House leadership have looked to us and said, tell us what to do. Where do we resist? What do we do? How do we stand on this? And so that's the latest information. And so with that, I'll throw that back, and if you've got brilliant ideas, we'll consolidate those together and take them to our House and Senate leadership.
Well, one thing that sparked my interest here is that, under other uses in that, you referenced PILT. So how does that play into this? Does that mean NGOs or whoever gets these conservation easements will pay a royalty to the federal government, which then would be shared to? And then, if you're talking oil and gas or something like that, now there's royalties that comes back from the production. So if they kick in a conservation easement, where as a state do we benefit from that?
Yeah,
Is
those
that in
are-
the cards? Because I think that's one thing that we need to be looking at, is that for us to be protective of federal land and let them do what they want at no benefit is not in the best interest of our state.
Yeah, those are great questions, Senator. To change multiple use sustained yield is a massive change. I mean, that was the promise. When FLPMA was passed, the promise was, don't worry, you'll still have all the benefits of ownership, multiple use sustained yield. The conservation leasing rule rips that rug right out from under all Western states. And so that's a whole new regime. And then, PILT was kind of a separate promise. Don't worry, you'll have, the fair taxable value. And so I think it raises really interesting questions of, if they're leased on these terms, does it become taxable? Can we assert that the land is then taxable? And is it taxable at the value of the sale of the environmental services? I mean, I think those are great questions that we need to be asking, that what that does. But the fact that it upsets and tears out the underpinnings of multiple use sustained yield. I mean, I'm sure that some of our friends in southern Utah would know, and maybe more, but that is a monumental change in the nature of land management, land ownership, land use, the economics, as you mentioned. This is a big, huge deal.
Well, it kind of opens the door up, because if we want to really have the discussion on PILT, have we ever seen an increase, or is the land value still what it was when it was first established? Because as we bring in these services, then wouldn't it stand to reason that they would be increasing in value, and that means PILT payment should be going up to the state instead of lowering it?
Yeah, I mean, I think that's an excellent question, right? I mean, there's kind of different levels of question. I mean, first is this tolerable at all, that they change the nature of multiple use sustained yield, would be, I think, an entry-level question. Another question down the road then would be, to the extent that they're going to change multiple use sustained yield, and they're now using it to value land and have economic uses of the land, does that not then set a value for what fair taxable value should be for the payment in lieu of taxes? Because the original promises on payment in lieu of taxes were that it would be trued up every year if need be to have the fair taxable value. And I think it was 2018, 2019, when unanimously we had every member of the House and Senate vote on, we needed to push and make sure that we're getting the fair taxable value. So, I mean, that's an excellent question that we need to explore on these different levels of what this means.
Okay, let's jump over to Representative Romero.
Thank you, Mr. Chair. First of all, I want to point out that you talked to the majority leadership teams. No one's talked with us. I'm the minority leader, and I just text Senator Escamilla. No one's had this conversation with her. So I want to be very, very clear. And I hate the route we're going now, because there are times where I felt like, we talk about the Utah Way all the time, but we were left out of those conversations. And for me too, I appreciate your presentation, but I just feel like we're not having balanced conversations in this committee. And Representative Ivory has been talking now for almost an hour, And I'd really like to know, what the federal government thinks on this, and people that are in charge of some of these programs. And so for me, I'm struggling right now because he's been talking at us for about an hour now, and no disrespect to you, Representative, but it's all over the place. Thank you.
Okay.
If I may respond?
Sure.
We just barely got back from these conventions. This information is coming so fast. The FedNow piece really just fell into place within the last couple of weeks, and so I was able to have conversations with some of the minority leadership at those conventions, and so.
Can you please
and
explain
if
who
I
you
may,
talked to?
Mr. Chairman, so we've just been able to have those conversations at some of those conventions, and so this is such new information that part of sharing this today is to get the information out so that we can have these conversations with all stakeholders in the state, because this is going to radically change the nature of how the 2/3 of our state that is publicly held by the federal government, change how that does so. I'm happy to meet with minority, meet with all stakeholders, and this information is coming at us so fast that we're just simply trying to put it together, and this is the first opportunity to actually share this publicly here, so.
Yeah, we've got a couple other topics that we'll be discussing today along the same lines. Representative Albrecht.
Thank you, Mr. Chair. No, I appreciate Ken's passion. I appreciate the minority leader's passion as well on both sides of this issue. What it's going to come down to on a state level is if we decide to run a bill, 3815-1, to give some direction to our congressional folks. That's what it amounts to. And so if we want to pass a resolution or some legislation to change policy, to affect policy, then, we do that as a resolution or as a statute. And, I appreciate you both and your viewpoints, but that's what it boils down to. That's why we're up here.
Thanks for answering my question.
All right, we're getting pushed on time, so I
Yeah, so
appreciate the discussion, but
just-
I think we need to actually go to public comment on this before we leave this subject, if that would be all right. And so if there's any public comment, Kel Weston, if you're on, we'll give you a couple of minutes to make comments, if you would. Having a little struggle here getting him on.
Yeah, in the meantime, I would just note that there were two separate agenda items, and so.
I can hear you if you can hear me. I promise to be brief.
Yes, go ahead. We can hear you.
Thank you, Chairman Winterton and members of the commission. I first want to echo what Representative Romero said. I think we're at a point in our state, fast growing, honestly diversifying politically, where it's incredibly important that we're talking to each other in the elected ways that you, I think, all intend and promise voters you're going to do. Up to 1/3 or 40% of our state feel like their voices aren't being heard right now. I want to shift a bit, and I took some notes to the convention of the state's report, and it reminded me of a big banner I saw in a big barn outside Cokeville, Utah. This is on my way to Wyoming to play with the elk, and it said, "A solution as big as the problem." Well, if I looked left and right and I saw a lot of James Madisons and Thomas Jeffersons walking around, I'd feel a lot more confident. But I want to talk specifically about the right to life issue, term limits, and public lands. I think if you were to ask public opinion pollsters across our country where we the people are on Roe v. Wade and what was overturned recently, you would find 60, 70% of our neighbors that were okay with equilibrium. So when this gathering happened, I think we've got to look at how representative of the people is this group. On term limits, I'm all for that. As someone who's run for office in this state in 13, 14, actually of 29 counties before CD2 was redistricted, it's one thing to say you can kick bad politicians out of the ballot box, but then redraw lines, so that's basically impossible. There is a bill, HR 1, that actually, I think, solves this problem by taking redistricting out of the political lane. On public lands, I don't have as much time to go into that again. Thank you, Representative Christopherson and Ivory, for giving a report about what you heard. I think the public lands issue, I'm the son of a downwinder, is a lot more complicated, perhaps, than what was just conveyed. And then finally, there was a statement that was made about ultimate power rests with the state legislature. With all due respect, whether Republican, Democrat, or neither of the above, I think that actually rests with the people. And I'm grateful that our Supreme Court in the state of Utah is looking at that question right now. So thank you for the time to speak. I think it's very topical. We've got the biggest Fed we have in our country coming to town in a few days, and these are incredibly important conversations. But please bring in your minority partners on this question. You've got hundreds of thousands of voters that look at these issues more similar to them than perhaps to the majority. Thank you again for your time.
Thank you. Okay, let's go over to Co-Chair Stratton.
Is there any more public comment? We're gonna close public
No, I
comment?
think that's all we had on.
Thank you.
Yep.
Appreciate the comments during the public comment, and I just remind all the committee members that as chairs, we've invited and asked for input on specific items, and we'll continue to welcome that. Appreciate the presentation on the second item on the agenda, the Article 5 discussion. Appreciate what's been said on so far on this third agenda item, and to the good minority leader, love to have any input on and perspective that would be available. That's certainly welcome, and will certainly help in the outcome as we work together and listen to one another to improve the outcome. But I think these are very serious issues we're dealing with, and that impact each of us and those that we represent. Significant economic impact on our way of life, and we need to recognize that and allow to have a good, frank discussion on that.
Okay, thank you. That's real quick, Representative Romero.
And I'm just going to reiterate to the chairs, I just want to have a balanced conversation. Maybe you all think this is balanced, but I don't. And so if you're going to have agenda items, I'm willing to see if I can get people here to talk on certain items. I just don't feel like right now we're having a balanced conversation. So I offer that. As you welcome that, I offer that, but give me a heads up and I'll work with you on that.
Sure, we'll keep that
Maybe
in mind.
I'd just say, here's the heads up. We have a meeting in October, so have at it, and let's get that input and that communication going. Thank you.
I would, Mr. Chair, I would welcome the opportunity to present on either or both of these agenda items to anyone in the state. Majority party, minority party, nonpartisan party, as Chair Stratton mentioned, these have tremendous implications for our state. And so, as I mentioned, this is happening in real time. I just got back Saturday. I put slides together yesterday, and this is the first time I'm updating at the request of the chairs. So if we have others that would like to come in and talk about these issues, I would love to have others come in and talk to that. But I put out the invitation now. I will share this with anyone, anywhere, and would love to talk to them about what this may mean for our state and what we do about it.
I think that's the purpose of this commission, is to keep the state informed on what the actions of the federal government and how it impacts our lives.
And my understanding was this was just to
It's an
update you
update.
on what's happened over the last few months, and so this is what's happened. If there's additional information, let's have that discussion.
Okay, now, we have some members that's got to go to another committee in 30 minutes, so that's going to be our drop-dead deadline, timeline for us, and we got a couple others, so let's invite those from the AG's office to come address us about the conservation leasing and ozone transport rule. We've got Jason DeForest and Dylan Hoyt. And then we also have Stan. Oh.
Right here.
Okay. I've got mics on for all three of you, so however you want to give your updates to the commission, go ahead.
Thank you, Chairman. I'm Stan Purser. I'm the Deputy Solicitor General from the Attorney General's office, and they've kindly allowed me to jump in front. I will give a very quick update on the ozone transport rule cases going on right now. Last time the committee met, you heard from our Solicitor General, and as she explained, the cases are now in two different courts. There's one going on in the 10th Circuit that is a challenge to the EPA's denial of Utah's state implementation plan. There's another appeal going on in the DC Circuit that is a challenge to the EPA's imposition of the federal implementation plan. These are both tied together, but they're in two different courts right now. In the 10th Circuit proceedings, Utah asked for a stay of the EPA's denial of our SIP. The 10th Circuit recently granted that stay, and helpfully to us also added some language that because the SIP denial was stayed, that the EPA could not enforce the FIP during the pendency of these cases. And the EPA has agreed, and they're going to issue an interim rule making that clear that they will not be imposing the FIP while these cases are pending. What remains in the 10th Circuit, there is still a motion by the EPA to change the venue, to basically transfer the 10th Circuit case to the DC Circuit. The 10th Circuit has not ruled on that yet. And the state of Utah has filed its opening brief. We anticipate briefing will be completed in October, we believe, under the current schedule. And then in the DC Circuit, the DC Circuit case, because it's a challenge to the FIP, involves a multitude of states. So there is a blizzard of sort of motions being filed and stays and this and that. But as far as our briefing goes, we have not filed an opening brief yet. We're not on schedule to do that yet. But when the time comes, a lot of our arguments challenging the FIP overlap with the arguments we've made in support of our SIP arguments. So that is the quick update.
Okay.
Any questions?
Yes, Representative Stratton.
So maybe in 2 or 3 sentences, the case in DC is stayed. Any action by the EPA?
It's stayed to the extent that the EPA cannot implement its FIP against Utah.
Okay. Then as we look at the actual rule itself, we're not challenging the rule. We're just challenging the denial of our implementation plan. Is there an actual challenge to the rule itself?
Yes. So I'm sorry if I wasn't clear on that. So the rule and the reasoning denying our SIP, we're challenging the EPA's reasoning and also the process they went through and the timing. So there's a challenge to their denial of Utah's SIP, and at the same time in the DC Circuit, we are challenging the EPA's implementation of a FIP, a Federal Implementation Plan.
Which is the rule itself.
Yeah, I mean, technically, there were, I think, two different rules, but yeah.
Is there a timeline to completion of the litigation? Approximate timeline. I'm just wondering, is this going to go longer than the current administration?
It depends, so the
Well,
10th.
which would, I'm assuming the current administration is re-elected, so 6 years or what's the?
Oh, yeah, I think it'll be done within 6 years, for sure. Will it be done within?
2?
A year, 2 years?
Yeah,
I'm
not likely.
I can't guarantee.
Thank you.
Okay, Senator Owens.
Yeah, thank you. Thank you for the presentation and updating us on this. Are you aware of other rules? You mentioned there's other rules in play that from the EPA. Are there others that you see as challenging now that we'll be addressing?
In this litigation, no, these are focused on, I mean, there could be related or underlying rules, but these cases are focused on the EPA's denial of our state SIP and then the implementation of the EPA's FIP.
Thank you.
Okay, Representative Ivory.
I was sitting down and trying to focus as you were starting. This is the ozone transport rule. How does it relate at all to the methane actions that have also been out there? That's completely separate then?
They are separate cases.
Okay. And then so from what you're saying, we've got issues on the ozone transport rule that was proposed, challenge to the rule itself, and then a state implementation plan were the rule to go into effect, and then the imposition of a federal implementation plan. So we've got, are those the three basic pieces that are out there?
Yeah.
The rule itself, state implementation if the rule goes through, federal implementation plan if the rule is enacted. Is that?
Yeah, and we view it, the rules are tied up with the SIP denial and the FIP approval.
Okay. But the way that the rule is proposed is these kind of dramatic changes take place beginning 2026. Is that kind of the first trigger date? Is that, as I understood it?
I believe so, that at least some actions or measurables need to be in place by then. But to meet sort of those guidelines, I think some of the industries would need to start taking immediate action.
And that's the question, right? That's the question. How do we deal with our industry and the protection of just basics of health, safety, welfare, energy, when we've got litigation going forward? We've got, depending on which way litigation may turn, we may have an implementation deadline of early 2021 to change over some vast percentage, 60, 70% of how we produce power in the state, right? So how do we deal with the economic, the practical governance aspects of how to deal with how we produce energy with that kind of a sword of Damocles, if you will, hanging over the head of our economy, of our ability to just keep the lights on? Does that make sense?
It does, and that's a really thorny public policy question that I couldn't answer all of that, but it's a very fair question.
Any aid and comfort then, because it is a thorny issue we're trying to sort through. I mean, it's as thorny as they get, I think, at this point.
I'm sorry.
No, go ahead, please.
When the 10th Circuit grants a stay, or when any court grants a stay, one of the first factor it looks at is the party asking for the stay, Utah, is there a substantial likelihood that it will prevail on the merits? And the 10th Circuit found in our favor. that does not guarantee we're going to win. But it is because one, it's a different group of judges that granted our stay, and there'll be another group of judges that decides our case on the merit. But these similar stays have been granted around the country. It's a positive sign for Utah that we have a strong case that looks credible to the courts. Now that doesn't provide a ton of comfort to the policymakers on how do we proceed forward. But I will note in all of these cases, both in the 10th Circuit and in the DC Circuit, that our industrial partners are also involved. They filed petitions also and are making arguments along the lines that we are.
But at least the way that the rule is proposed, if we were to lose, we're having to completely recalibrate our entire energy production by the beginning of 2026.
It may be that I believe the court would have the power, and perhaps the EPA, the reasonable solution to this would be, given the stays and the time the litigation took, that any deadlines we'd be under would be extended to allow for a reasonable compliance.
And those are all based on the equity powers of the court, but the way it's written, that's the way it would come down if we were to lose. What else is out there in addition to this methane? Are there other things, other rules, actions from our federal partner that destabilize our energy infrastructure that you're aware of?
Well, there's a case right now also involving the Clean Air Act and the in-state air quality standards that the state also tries to pass a SIP on. There is that case. Then off the top of my head, I'm not thinking of any others right now.
Okay, let's jump to Senator Hinkins.
My question is who's actually the deadbeat neighbor when 95% of the power that comes from Utah goes to California, but yet California's suing us for being the bad neighbor, for polluting their air, the power that they're consuming. So who's actually the deadbeat neighbor, us or them?
I don't think he wants to answer that.
Our case, well, and not to comment on that, but the problem the EPA found was our air going into Colorado. And one of our arguments is that whatever we're contributing to Colorado is insignificant to what Colorado and other sources are producing themselves.
Okay, so the Hayden Station and the Craig Station, I mean, that's in Colorado, generating all power that goes to Colorado. And so that's basically, you can't decipher whether it's the Hunter and Huntington plants versus the Craig and the Craig Station and the Hayden Station.
And at least to the extent they can determine where the pollution or the air quality problems come from, Utah's stance is what we're contributing does not meet the standard under the Clean Air Act to impose a FIP on us or to require us to impose, the hundreds of millions of dollars of changes on our.
So we don't have a lawsuit against us by Colorado. It's only Colorado, not California.
Yes, and it's not per se that I'm aware of Colorado hasn't sued us. It's just the fact that the EPA has determined Utah is contributing above a certain threshold to the air problems in Colorado. Okay. Therefore, Utah has to have a FIP imposed.
So then, I'd like to come back, Mr. Chairman. So then, are we in a joint being sued, us and California, by Colorado, or just Utah? Because California consumes 95% of the power from the IPP power plant.
As far as I'm aware, the EPA did not impose this FIP on California.
So that's
I believe that-
discrimination against Utah, basically. Thank you.
Okay, Representative Snyder.
Thank you. I am here just to further aggravate my colleague to the left, so I wanted to ask some more questions. That's why.
Well, let's make it
If I may, Mr. Chair.
quickly.
Okay. So one of the questions that I had is regards to our own regulatory agencies. So as you're moving forward with this law case, what level of support are you seeing out of our environmental quality agencies? Are you seeing a robust modeling that can dispute some of this as it moves through the courts? Are there things that we can do further within our own regulatory entities to mount a more aggressive defense against this type of stuff?
Part of the answer to that is, well, yes, from my vantage point, our agencies, the relevant agencies are very involved and very robustly involved and are using the best available technologies and modeling and methodologies to support our state implementation plan. One of our arguments in these cases is that we worked with EPA for 2 years to get our plan approved, and EPA didn't say anything, that, oh, you've got a problem here, there, or anywhere. It just sort of came out of the blue that here's a FIP and your SIP is denied. And so that's one of our arguments, that this isn't due process, it's more arbitrary. We have a very supported SIP.
Thank you.
Okay, Representative Albrecht.
Yeah, thank you, Mr. Chair. I just want to go back to what Senator Hinkins said. Great point, because in Colorado, you have the Hayden and Craig coal plants, which are northwest, central part of Colorado. They could be doing the damage rather than Utah. Right. And it's really an unfair suit. I mean, unfair regulation by EPA. Thank you.
Senator?
And it's basically more than unfair because, you know, Rocky Mountain Power and like the Hunter Station, we've spent $600 million on bag houses, where the Craig Station and the Hayden Station have done zero. And so Utah should, you know, we should be pointing that out, that we've actually invested in it, but it's never enough. You invest that, and then the next time, a year later, you haven't done enough. You got to do more. So it just never ends. It's just until they, anyway.
Recognize what we've done and give us credit for that.
Thanks.
Okay, we got Senator Kwan online. If you'll unmute yourself, go ahead.
Thank you, Mr. Chair. So my question has to do with the difference between what the EPA expected our emission reductions to be and what our emission reduction, or I'm sorry, the SIP plan to have in, oh, I'm saying this wrong. What was the emission reduction that we said that we would have in the SIP?
As I understand it, our SIP was that we did not contribute. Well, I'll back up a little bit. The Clean Air Act, as far as this good neighbor rule goes, the standard is a significant contribution. Utah's argument was we are not a significant contributor to the air quality problems in Colorado. Therefore, we don't have to do anything, at least under the good neighbor provision, to reduce our contributions to Colorado. And the EPA disagreed and said, yes, you do. And the precise difference, I'm sorry, I don't have it at the tip of my tongue right now.
So if I may follow up with that. So I think, was it section 110 of the Clean Air Act that says something about the downwinders, was that the section that said that we do contribute, that we were found, Utah was found to contribute, and so that is why we were named as one of the western states who would need to reduce our emissions? Is that correct?
Yeah, I believe it's under that provision that has the language.
Okay, thank you. I think that the conversation here has been focused on blame, but I really do think we need to think larger than that. We do have an issue that we need to fix, or at least try to alleviate. We've got wildfires going everywhere. We've got different kinds of weather patterns. We've got heat rising throughout the nation. And if Utah has been found to be contributing to downwinders, that is an issue that I think we do need to look at and how we could mitigate that. So I think that probably is separate from this lawsuit, and I do appreciate you giving us this input. But Mr. Chair, I think that this is a larger conversation.
It is, and again, these topics are to inform the commission of things that are transpiring, and some of them quite quickly. Chair Stratton.
Thank you.
To clarify from last statement, the state implementation plan found that we were not contributing. Is that correct?
Yeah, that's my
So the
understanding.
best side, I guess I would clarify my understanding is different from the prior statement. There is not a problem.
From Utah's
From our
vantage,
perspective,
as
that
far
we
as
are not polluting other states.
As far as the good neighbor provision,
Right,
yeah.
okay, thank you.
Well, thank you. It was a good discussion. Now we'll go over to Dylan Hoyt to give us an update on, is it conservation leasing? Yeah.
Yeah, Dylan Hoyt, Planning Program Manager at the Public Lands Policy Coordinating Office. I particularly just wanted to give you an update on the Conservation and Landscape Health Rule and the component of conservation leasing within that. Back in April, the BLM proposed this new rule. It was extensive, and our office took the time to tease it apart and figure out where it was inconsistent with our state goals, objectives, and policies, as well as federal acts. So for example, the BLM is governed by the FLPMA, or the Federal Lands Policy Management Act, and a lot of our comments that we supplied were to the effect of how the proposed rule is inconsistent with FLPMA and what is approved by Congress. Kind of goes to that saying of the finish line keeps moving a little bit. I will mention that, one of my jobs at our office is the State Resource Management Plan updates. And within that, in the introductory section, we talk about how the state of Utah supports wise use, conservation, and protection of public lands and their resources, including well-planned management prescriptions. It is the state's position that public lands must be managed for multiple use, sustained yield, prevention of waste of natural resources, and to protect the health, safety, and welfare of the public. Those are the overarching themes of why we do what we do, and we do that through coordination and cooperation. And when we're unable to do it through coordination and cooperation, that's when we do consistency reviews, that's where we do litigation. And with regards to conservation leasing particularly, it seems like conservation is being proposed as a hands-off management technique, which does not work. We know that management makes the difference. We just ran a public education campaign on that component. And we have a lot of programs in the state of Utah that are already doing a lot of this active, what we might consider conservation, that is a different definition from what the BLM considers conservation. Some of the troubling things that came out of the conservation leasing component of the proposed rule are that qualified individuals, businesses, and non-governmental organizations or tribes qualify for a conservation lease, but the state and local governments and counties do not. So that basically takes us away from the table and away from the opportunity to coordinate and cooperate with our federal partners. Furthermore, when we talk of NEPA and how NEPA applies to FLPMA and the different acts that are within there, for example, the Tailored Grazing Act, or possibly the Public Rangelands Improvement Act, as well as FLPMA, we don't know what a conservation lease would look like under NEPA. It is not spelled out in the proposed rule. It may not even be required. And if it's not required, then there again, the state is left out of the conversation. And the last thing that I will say is that the leases in the BLM rule are for 10 years, and those can actually be renewed every 10 years in perpetuity. So if something goes into a lease, does it ever come out? And there's this component of if there is a lease, then you can't have an action in that lease that is inconsistent with the conservation use, which beckons the question of whether grazing is inconsistent with conservation. And with that, Jason, do you have anything to add?
No. Thank you, Dylan. Jason DeForest, Assistant Attorney General with PLPCO, the Public Lands Policy Coordinating Office. I was just here merely to support Dylan. I handle endangered species related stuff at the office, and I was going to talk briefly about how some of those issues are continuing to contribute to management on public lands, particularly as it relates to conservation leases. But in the interest of time and staying on topic, I'll leave that for another day. There are some pretty significant new regulations coming down the pike that I'm sure you will all be aware of regarding the CEQ regulations that will affect conservation leasing. The Council for Environmental Quality regulations that will affect the implementation of NEPA as we go forward in these conservation leasing programs, as well as some endangered species related regulations that are proposed to be changed in the near future. But I suspect that I will be back in sometime in the future to talk about those on another day. So thank you.
Representative Stratton.
Thank you. Based on what we've heard today and some of the narrative and dicta that we're seeing out in the landscape, going back to grazing, it doesn't seem then that it's too far to say that no more grazing in the state of Utah. Is that correct? Is that, I mean, that's a step, but let's say it for what it is.
I think
Seems
that
like that's
could
a stretch
definitely
we're
be
going.
the worst case scenario.
Well, it would be worst case, but
yeah.
it seems like that's a likely outcome.
It's definitely an
we're gonna shut it
agenda
down.
item, right? And
Yeah.
I would just add this, there is some case law that makes it very difficult for the BLM to do what they're trying to do on the basis of multiple use sustained yield, right? So if we look at some of that case law, there was a ruling out of the 10th District Court that said that the BLM lacks the statutory authority to prioritize conservation use to the exclusion of other uses. So if they place conservation above grazing, which is one of the main priorities of the BLM and the multiple use mandate, they're inconsistent with existing case law as well.
If I may add to that, Mr. Chair, one of the other issues I was going to discuss was the implementation and the emphasis on ACECs from the BLM. So on the one hand, you have conservation leasing and how that will affect grazing across the landscape. And then on the other, you have an emphasis on ACECs that will also affect range management and health of the range and whether grazing will still be allowed. And those things collectively could result in a worst case scenario that you're speaking of. So that's why it's of significant concern, right? The two together and how they will affect our grazers throughout the state.
My point is, I just don't think we can overstate the critical nature of the real, I hope it's an unintended consequence. We're not thinking things through at the federal level, which, given the benefit of the doubt, but it seems, in best case, unintended, but just a malicious impact on our economy and well-being and our life here in the state of Utah. Thank you.
Okay, Representative Ivory.
Thank you, Mr. Chairman. I'm struggling to see how this isn't directly contradictory to the multiple use sustained yield, which was, I mean, that was the very foundation of FLPMA, right? That's why Western states signed off on it. It's going to be just as good as ownership, multiple use sustained yield. How is this not directly contradictory to that?
It is. If we take a step back before FLPMA, which was 1976, if I'm not incorrect, the Taylor Grazing Act had been in place for probably 40 years or so before that. So when they wrote FLPMA, they basically wrote FLPMA around the Taylor Grazing Act and saying, we're going to do these promises that we're going to make you. We're not going to take away your grazing rights and opportunities. And we're going to stick with this mission of multiple use and sustained yield. And when we go back to the spirit of the law, if you will, in 1976, I think we're misinterpreting that in 2023.
So the proposal is by a proposed rule to directly contradict and undermine statute.
Correct.
Which is arguably then undermining the constitutional provisions that all of the states east of the Rockies had. I mean, multiple use, sustained yield, and Tailored Grazing Act were a step down from the Constitution and Enabling Act rights recognized to the states east of the Rockies. And then that was codified by statute in '76. So now we're just seeing by rule. I mean, am I reading that wrong? I mean, that's...
No, I think you're reading it right. Almost all of the things that our office works on, tie back to Executive Order 14008, which was right when President Biden took office.
Right.
And I think you're reading the situation correctly. And when we worked together as a state public lands office to put in public comments, we tied back to all the case law, all the the acts and all the statutes to show why what is being proposed is simply not legal.
And then in deference to my good friend to the right here positionally, if not ideologically, I would love to get people from the BLM, from the DOI. I would love to have them in here, that we could have these people to speak to them about the nature of this and what the legal authority is. So if you could look into that for future meetings, I would love to have that discussion. So in all of the actions that farmers or ranchers or counties or others may want to do, there was a very strict adherence to NEPA and environmental impact and economic analysis. Is there any environmental impact studies, economic analysis, environmental impact? Has any of that been done on what this would mean?
No. There's an argument out there that this proposal shouldn't have advanced at all without having gone through NEPA. And that's a pretty strong argument.
And is it fair to say then, other like proposals have all had to go through that step of NEPA and environmental impact and economic analysis and consistency and reviews, all of the rest, right?
Yes, I'm trying to think of the example, and I'm not thinking of it right now, but there's actually a very good example of that as well.
So what we're seeing is, again, not only is it just a rule trying to defeat a statute that already defeated Constitution and Enabling Act, it's a rule that's not even following its own rules.
I remembered my example. It was actually with the Sally Jewell coal moratorium, where they said you need NEPA, and then there was a backpedal, and they're like, but we don't need NEPA, and then the courts actually made them go forward with NEPA, which added time to that moratorium.
Okay. And I appreciate that. So would you agree with me then on that we have a rule trying to defeat a statute that defeated Constitution, and that rule isn't even following its own rules to be enacted in terms of NEPA and environmental impact and that sort of thing? Does that seem to be what's happening?
That's the general consensus.
Thank you.
Okay, Representative Romero.
Thank you, Mr. Chair. And so I take what's been thrown out there by all of you and what's being presented here seriously. So if you all could just kind of define that, I will personally send that email before the week ends to see if we can get someone here for our October meeting, whether it's Zoom or whatever, to address these questions. I just want to make sure I'm not spinning my wheels and my political capital if we're not going to put them on the agenda.
Well, we have time to have that discussion and see what direction the commission wants to go. All right, well,
You know the deal.
I did hear somewhere in there that there's if or maybe suggestion that we will have to have a bill opened to address maybe the RMPs, some more updates on them to
Yeah,
to address those?
I've been preparing some recommendations for this commission to potentially do what you just described. A lot of those are being taken from this conservation landscape health rule, and the lessons learned there is along with the many other things we've learned over the last year. And I should have that ready to send out to the commission within the next 2 weeks, probably. It has to be in by the 31st.
Thank you.
Thank you. Okay, we'll just move on just a little bit. We do have an item here, coordination with the other interim committees, and we're going to turn the time over to Jacqueline to kind of brief us on those. So,
There we go. Thank you, Mr. Chair. I'm Jacqueline Carlton, attorney from the Office of Legislative Research and General Counsel. And we kind of previously discussed this new reporting requirement in our first meeting. But just briefly as a reminder to the commission, HB 253 amended the statutory duties for the commission, and so now there is a reporting requirement in statute that requires the commission to provide an annual report to each interim committee concerning any law or action by the federal government that implicates the principles of federalism or state sovereignty. It also allows the commission kind of the discretion to notify the appropriate interim committee as well. But there is now a new statutory requirement for an annual report.
so can that be a written report? It needs to be an oral report, but we need to coordinate with them and report to them, right?
Yeah, so annual report, I mean, it could be written or oral, but it says to each interim committee. So I leave that up to the commission how much they want to do
To each
that.
committee or to ones that might have?
To each interim committee, an annual report.
Somebody's going to be busy.
Give an oral report in November to all of them.
Okay. Representative Albrecht.
Thank you, Mr. Chair. I'll just be brief. I would like these items added to an agenda. Number one, the U.S. Forest Service ruling on e-bikes that they've just come out with. Why in the world are e-bikes considered motorized vehicles? I mean, we got a lot of older folks that can't pedal all the time, and e-bike is the answer to their prayers. And they're not a motorized vehicle. If we're going to EV batteries, EV bikes should be considered.
They're green, right?
Right. And the other thing I would like to hear about is federal regulations concerning gas stoves, our refrigerators, our air conditioning, our lighting. What jurisdiction do they have over those things?
Portable generators.
And number three, if President Biden comes to Utah or Arizona and declares a monument on the Arizona Strip that locks up our uranium and our grazing for our southern Utah grazers, we need to know the costs and implications of all of that to our energy supply and to our southern Utah grazers all along the border. Thank you.
Yes, thank you. Those are good topics, and I think we have many eyes on those topics, and we need to address that. That'd be a good place to start for October also. I don't see our other presenter here. I think what we will do is we'll put him on the agenda for October to give us an update, and today's was just going to whet your interest on the water situation, and so we'll have him come down from 30,000 feet down to the ground or a little bit more. Oh, I see Senator Kwan, you've got your hand up. You want to make a comment?
Thank you, Mr. Chair. What I'd like to have clarified is whether or not I've heard several committee to commission members talk about having expert or people with expertise on policies to answer questions. And what I'd like to ask is whenever we have something on the agenda, if somebody with expertise on the background on those policies so that we can have questions answered about the whys and the how do these work.
Okay, you cut in and out pretty bad there. I think we got the gist of it, but you would like to have this information on the agenda out earlier so you can have a robust discussion, correct?
Well, I apologize for my Wi-Fi. I didn't realize I was having issues. I hope you can hear me now. The question that I had was to have, or the comment was to have, not consideration, but to be assured that we will have people with expertise on some of these federal policies to give us some of the backgrounds and answer questions. I think a number of people on the commission have said that they would welcome the discussion, and I just want to be assured that that will occur in future meetings.
Well, that's our intent, is to inform everybody so we can make good decisions.
I would just say to that point, and the general discussion, you give invitations, but oftentimes they're not able to come. So I'm not sure as chairs, I will just say this, we've asked the commission members to have an offer input, and I'm not sure, maybe just check to make sure that that input was sent or confirm it, we received it, work with our staff on that, but we certainly welcome it, yes. And we don't need to rely on, as chairs, we are probably, who would you have us invite? Would it be the director of the BLM here in Utah, the director of the forest? Would that be what you're referring to, Senator?
Sorry about that. I think that probably I would need to we would need to look at all of the different issues that we were going to talk about. There, certainly the director of the state director of BLM, and I just forgot his name. Sheehan, Mike, I think.
Greg Sheehan.
Okay, thank you. Yes, would be one person that I think would be a good person to ask, but there are probably other people for other issues that would be important to ask.
I appreciate the role of the Federalism Commission, again, statutorily, is to look at the principle of federalism and the interface with our federal counterparts and agencies and so forth. So that's is completely aligned. Sometimes we have more of a reception than others, but we will continue to invite and ask, so thank you.
Okay, Representative Romero?
Yeah, and to follow up on the good senator, if you need our help with making some of those reaches and requests, we're more than willing to do that. I just want to make sure, I know we're majority people on this commission where they're at, and I've been in the legislature now for almost 12 years, but I really want to make sure that we're having balanced, robust discussions, and I'm willing to try to identify some of those people if given enough notice. I will do those outreach. I will do those emails directly to my contact at the White House. Or if it's someone that I know understands kind of what we're talking about here in Utah, because I think it's very important that we have a balanced conversation regardless of where we feel. Like, I mean, there's lots of things that pass this legislature that I don't agree with, but it passes. But for me, as an elected official and someone who represents a lot of people here in Utah, just like all of you do, I want to make sure that people can't point fingers at us as a state legislature saying we only do things in favor of one particular political party, because we're not here based on political party, we're here on policy. So I want to make sure we're having robust policy conversations. That's all I'm requesting.
I think if I may respond, is you look at the number 3 agenda item, the administrative cap and trade, conservation leasing, ozone transport rule. We'd love any and all, any voice, because I'm concerned that there has been a lack of that robust looking at all sides, and we're going down a path by those that we'd like to hear from and ask the questions to, certainly in a civil, appropriate way. To recognize that we may be out of touch with what's really important to the American people.
Representative, I might be out of touch. I guess what I'm asking is, when President Trump was in office, you didn't see me making snide remarks about him here in the legislature, because I respect the President of the United States, whoever that person is, because they're the President of our country. And so I just want to remind you all, you may not agree with the current administration, you may not agree with some of their policies, but it's about the respect for office. And so all I'm asking is, when we do this stuff, we disagree with respect, because at the end of the day, the person who's in office is the President of the United States. Whoever is in Congress, like, I don't necessarily agree with our congressional delegation, but I still give them that respect, and I'm respectful to them when I interact with them. And we can challenge policy, but I don't want to get into the theatrics and put pictures of, or put little screenshots of a particular president, what he said 5 years ago or 10 years ago. I don't appreciate that. That's all I'm saying. We're going to be respectful. Let's be respectful and do it with civility.
I think I'm saying the same thing as you are, and I think that's true, so.
Okay, Representative Ivory.
Thank you, Mr. Chair. I think I would like to also add to the list that Representative Albrecht mentioned. The portable generators have been brought up, that there is an administrative move to ban even portable generators. And then I think on the water, the deep dive into water jurisdiction, we've seen diligence claims from the Forest Service and others, and then intrusion from the federal actors into the Colorado River Compact, where there's not authority. And then with the chairs, we had a vote a couple meetings back to look into this mandamus and what it would take to get the executive, both the governor and the AG, to come along and see if we might join the northeastern state on that mandamus action. And so if we have a report back there, and then I may have missed the discussion on what coordination with the committees were that we had as a line item. I don't know what the discussion was there, but what we're doing with that.
Somebody passed a bill that requires us now to coordinate and to report back to the other interim committees, so.
Was there action discussed on what we're doing with that then? I might have missed that.
We didn't get to that point. It was for information that
Okay.
before the end of the interim, we will have to report to these committees. So
Okay.
I guess we'll gather the information and those topics that are pertinent to inform them on, and we will do that.
And then I would just like to state, I was asked to provide an update of information. And so I provided update of information to this committee of things that are happening nationally. We had a very substantial a simulated convention of states, and we reported on what's happening there. There are a number of states that are working on Article 5 issues that are as fundamental to federalism as there can be, and we reported on what's happening with those. And then there was a conference of state legislatures that discussed what's happening on this cap and trade front. And I fail to see how it would be disrespectful to anyone to share a small clip of what that former president actually said. I mean, I don't know that it's debatable that was said, and that there were actions, in fact, to try to pass a cap and trade system that failed, and that was simply shown as background and foundation for what we're now seeing as a cap and trade system that's been implemented by executive order and administrative fiat. And so I fail to see how that is any sign of disrespect to show the actual statement of our former president and what he said as far as his intention for energy and what has happened in the intervening period. So I did my best to try to simply report to this committee on the things that have happened. And I'll state again, I'm open and welcome the opportunity to share this same information with anyone at any time, wherever we go. I got back on Saturday. I've been dealing with an extracted tooth that had some issues, and so I put the information together as soon as I could, and this is the first time to share that. I'm happy to share that in other venue and fora as well, but the insinuation that somehow simply sharing the information is unbalanced or some, this is what the experience has been in committees and in these conventions and in other places, and we've not taken any action. And again, we welcome information from other sides. I'm simply sharing the experience that we've had, and I take issue that simply sharing that experience, as I was asked to do, is somehow unbalanced. Those are the experiences that we've had. That is the information that has been developed in other meetings, and I've simply shared that at the request of the chair. So,
Okay, I think that all of us have the same goal, that we want to be able to make decisions with all the information that's available and to do it in the best interest of the state of Utah.
Maybe what we'll do is ask staff to follow up with all the commission members to see if they'd like to follow up on any of these items, and if there's another perspective, please state what that perspective is, and we'll consider having that on the agenda, and certainly, as we've said, we'll welcome it. So let's do that, okay?
Sounds great to
Follow
me.
up that way. Thank you so much.
Okay, with that being said, then I entertain one final motion.
Motion to adjourn.
Okay, that's undebatable. We are adjourned.